Ladies and gentlemen, welcome to the Weekend Review. I am your lone wolf Usul. I am here to bring you some great cases today. We're going to get started with things in the middle lane with Judge Middleton. We're going from mild to spicy today, ladies and gentlemen. Stick around for the whole show. Right after Judge Middleton, we're going to go to Judge Frank with some frank words for a lying thief, and Judge Nels for some shaky shabusiness. Stick around. It's all getting started right now.
All right, let's see who we've got here. We have Michael Lord. He's here. Is any Miss McNeese, which case are you here on?
That's the defendant on my case, Your Honor. I'm here for portfolio recovery.
All right, he has two. He has one portfolio recovery and one LVNV funding. Mary Salter is here on behalf of River Run Transportation. We're going to have some issues to address in that matter. I guess we can take up Mr. Lord's portfolio recovery case. As I mentioned, he has two. Mr. Lord, can you hear me?
Yes, Your Honor.
All right, I'll fill it up when I get a chance. You can have that one. All right, I'm going to call this case. It's entitled Portfolio Recovery Associates versus Michael Lord. The claim was for $3,016.02. Portfolio Recovery filed this lawsuit on October 15th. The defendant was personally served, allegedly, by Rodney Woods on Sunday, December 29th at his residence in Colon Road. Says he refused to sign. So there's evidence that the defendant was personally served. He didn't respond, and a default judgment entered in the amount of $3,157.17. Mr. Lord then, once the judgment entered, which was entered in February the 18th, filed a motion to set aside the default, and that was filed on March 6th. So it was within 21 days of the entry of the default. Although he doesn't state any defense, he says no notice given. So he's claiming lack of service, as I understand it. Is that your position, Mr. Lord?
Yes, Your Honor.
Mr. McNeese, Ms. McNeese, do you have any response?
Just briefly, Your Honor, pursuant to the court rules, in order to set aside a judgment, there must be both good cause and meritorious defense. As you previously noted already, we filed the proof of service indicating that Mr. Lord was personally served. And additionally, there has been no meritorious defense presented. And so we do believe that this motion should be denied.
Your Honor, if I may
Yes.
explain real quick. The no notice given, yeah, I never received any papers. The refusal to sign never happened. Which it's fine. I'm not worried about that. I did do the motion to set aside, and that was my fault that I wasn't there. I knew I had court that morning. I had to be at work, and my immediate supervisor's mother-in-law passed away. And so there was just enough on my plate that day to where I actually completely forgot about the meeting until about an hour and a half later. So I understand the default judgment in that, and I'm not even trying to argue any of their claims. I know I owe the money. It would be really nice if I could, because I have like 3 or 4 cases with portfolio recovery. Some are resolved and a couple are pending, and I would like to just get them all wrapped up to where I can set up one easy payment plan on direct deposit or from direct deposit, and I could resolve them all. It's just that I have so many from, and it's my own fault. I have so many from portfolio recovery that it's kind of hard to keep all them numbers, keep track of all them numbers, to be
All right,
honest.
well, let's talk about that. So you acknowledge no good cause for failing to appear, and you acknowledge the debt. You knew of
Yes,
the court proceeding. All
yes.
right, I'm gonna deny the motion to set it aside. Defendant acknowledges the debt. Ms. McNeese probably isn't in a position to discuss all of the cases that you've got right now, but your proposal makes sense. Get all the portfolio recovery associate cases together and try to work out a plan. Ms. McNeese, how would you suggest he go about that?
Yeah, so I would just ask that he give our office a call, and he can speak to somebody here that would be able to look at each one of his accounts that he has, and figure out a way to facilitate that. We are more than happy to work on a payment plan arrangement, and also we have auto pay, so.
All right, why don't you give him the number you wish him to use?
Absolutely. Are you ready, Mr. Lord?
Yes, please. Mention for that, because I did try to call, and the guy that I talked to, I could barely understand him. He was not English speaking very well anyhow. I'm not trying to make no jokes or anything. It was extremely hard to understand.
Understood. Yep. So you can use my extension, which is 147.
Awesome. Yep. Thank you.
All right, Ms. McNeese, I've denied his motion to set aside the default. And we're going to address his next case with LVNV funding, but you're good to go on about your business.
Perfect. Okay, thank you, Your Honor.
You might want to sit in on this. What?
Do you need us to file an order reflecting your denial?
I've got an order that I think the staff prepared. But I would ask you to stick around for just a moment and watch this next case, which also involves Mr. Lord. All right, we've got iPhone, Mr. Richard Rusin. Mr. Rusin, good afternoon.
Hi, Judge. I hope you're well.
Yeah, I'm doing fine. Mr. Johnson, on behalf of Credit Acceptance, we'll get to your case in just a moment. Ms. Salter, you as well. The next matter is entitled LVNV Funding versus Michael Lord. Mr. Lord is here by Zoom, and Mr. Richard Rusin is here on behalf of LV Funding for the firm of Rusin, Varchetti, and Olivier. We just dealt with another one of Mr. Lord's cases, and this one is a smaller one, 93429, LVND funding versus Michael Lord. Mr. Lord was served with a lawsuit allegedly on January 6th of 2025 at his home in Colon. Mr. Lord did not answer the lawsuit and a default judgment entered. And then he filed a motion to set aside the default, saying he was not personally served and did not have notice, no notice given. Mr. Lord, the process server, her name is Samantha Donahue, swore that she served you at your home on January 6th at 4:48 PM. Did that happen?
I don't believe so, but if I seen a signature, I would be able to tell you if it was mine or not for sure, but it's okay. I'm here. I'd like to get it resolved.
Okay. Mr. Rusin?
Judge, if I can go forward, a couple of things have happened and I can
Yes.
provide the record. Mr. Lord has contacted my office and spoken to my staff. And in turn, I have gotten approval from my client to do two things. Number one, I will stipulate to set aside the default judgment, and I will submit the order, probably not today, but on Monday. And I will also stipulate to a second order that will be essentially a conditional dismissal under MCR 2.602C, I believe. And Mr. Lord is agreeing to settle this case by means of the conditional dismissal, whereby he will pay a total of $900, and that will be at the monthly installment rate of $150 per month, beginning April the 4th, which is, of course, today. And so those are the two things. Now, of course, in the conditional dismissal, I'll state this for the record. The court is aware of it, but have to make Mr. Lord aware. If any of the monthly payments of the $150 are missed, that conditional dismissal, Mr. Lord, will provide that I can come back to the court upon filing of an affidavit of default of your monthly payments, and then I can, in that same, what's called the conditional dismissal, ask that the court re-enter the judgment against you by default, with, of course, payment credit for whatever payments that have actually been made. The beauty of it is that there will be no judgment entered against you, Mr. Lord, because I'm agreeing to set aside the default judgment today by one order, and then by the second order by the conditional dismissal. And since we're on the record today, I would suggest that if this is an agreement to the defendant, I will submit those proposed order by 7-day rule. Just so Mr. Lord understands, it means that under the court rules, I file a copy of the two orders with the court. Mr. Lord Mr. Lord, get a copy of it. And if there's anything that's inaccurate for what is being said today on the court record, then Mr. Lord, you have the right to file a written objection to the entry of that order saying, this is wrong, this is wrong, this is wrong, whatever. But if you don't file anything in writing, because it's everything that I'm going to file with the court based on what we're saying today, then the judge will sign under the court rules those two orders with his signature, enter those orders, and those orders will then be sent out to us, including the conditional dismissal with the settlement terms. With that, I rest.
All right, Mr. Lord, is that agreeable to you? They will set aside the default. They'll re-enter a new order called a conditional order of dismissal with $900 as the amount, which is some consideration, probably several $100s. And then you'll pay that at $150 per month. They'll send them to you. You have 7 days to object. If you don't object, the order would enter. You understand?
Yes.
Is that agreeable with you?
It is. I would like to know real quick, do they have auto pay? Because that makes it just so much cleaner. I don't have to forget on accident or anything like that. It just comes right out of my checking account.
Yes, yes, I would. And the answer to that, Judge, on the record, because I do the same thing all the time, I would urge Mr. Lord, after this hearing is concluded, and he leaves the Zoom electronic courtroom, he can feel free to call my office today, call my office Monday, or anytime it's convenient to him between the hours of 8:30 a.m. and 7 p.m. He can walk through my staff, his question through my staff, and my staff can guide him as to doing that automatic payment. We've done it before. My staff will be very helpful.
Why don't you give him that number right here?
Okay, well, he can call my landline, 37. My staff will be delighted to talk to you.
Thank you. I'll call you right after work at 2:30.
All right, Mr. Lord.
All right.
Thank you. Mr. Rusin, stick around for a minute.
Yes.
Well, you know, the smart wolf that I am, I cut out the interesting part of that where he blesses that lawyer out for the process servers never being on time and not doing what they're supposed to. But ladies and gentlemen, that aside, we're going to a new judge, or a newest judge for me, Judge Frank. He's got some frank words for a lying thief, and it all starts right now.
In the matter of People versus Gonzalez on 247039, appearances for the record.
Good afternoon, Your Honor. Anthony Gonzalez on behalf of Ms. Gonzalez, who stands to my left. I'm covering for the attorney of record, Aubrey Smith. Ms. Gonzalez, you okay with that?
Yes.
Your Honor, we did go over the PSI in this case. There's no additions, corrections, or deletions outside of her employment information. She has interviewed at Corning out in Hemlock, the factory out there. She's waiting on the start date now.
Anything else by way of elocution?
Your Honor, I'd ask you to follow the recommendations here. I believe they're appropriate with what we are looking at here. As noted in the PSI, Ms. Gonzalez has a very limited old record at this point. I don't believe that any of this conduct is going to carry out moving forward. The fines cost, let's see, CSD class, I would ask 90 days to give her time to pay since she's still waiting on a start date.
Anything you want to say, Ms. Gonzalez?
No.
So when I read through the record, so you said that loss prevention followed you through the store?
Yes.
Why do you think they followed you through the store?
They were following quite a few people. They had quite a few arrests that day.
Did you notice one of the sentences in that report? Did you read through the report that was provided to your attorney and what it said?
We looked through it. I don't know what specific sentence you would be referring to.
How she was targeted for having prior magnetic fingers going through the store?
Oh, the police report, Your Honor?
Yep.
I don't have a specific police report here for us to go over.
No, it would have been the loss prevention report that was included
We don't,
on the police report.
I don't have.
And then the assessment there, what you said during your interview with Ms. Slaughter seemed to not be what was in the police report. So why is that?
But when
You said that you just, let me interrupt you. You said that you were just throwing the keys to the other person. However, everyone else seems to think that you were getting ready to leave and you were not the nicest person to begin with.
yeah, when I was tossing the keys over to her,
Uh-huh.
they thought that I was trying to leave. And then when I actually got them over there to her, that's when they put me against the wall and were shaming me. That's what I was telling
And that's your story.
the other lawyer. And she just told me just to make it short, just so just to give it the kind of the gist of what was going on. So I didn't explain everything the last time I was on court.
While waiting for a marked unit to arrive, you became disorderly by standing up and trying to leave. I gave several verbal commands to back down, which she refused and tried to push past the employees at Target. At that time, I informed you she was under arrest and put her hands behind her back, which she refused. This must have been the deputy. I grabbed both her arms to place them behind her back, but she tensed up and pulled away. Hence the R&O. And you not following commands, and you trying to leave. I grabbed her arm and told her to turn around, but she refused and was trying to face me. At that time, I forced her against the wall, control, yada, 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 police work. Let's see, what else? So why have you tried your career at stealing?
That time, I didn't know that it was the two rugs that were together.
Oh,
'Cause
bullshit.
they were both scanned at the same time. They were
Yep.
small rugs.
So how many times, I don't expect you to answer it because you'd probably incriminate yourself, but let me rhetorically ask the question. How many times have you stolen from Target before? Because you clearly are a thief.
I have changed my life.
No bullshit. You lied to Miss Slaughter.
I
Now
didn't-
you're lying to me.
I didn't lie to Miss Slaughter.
Oh, I guess you did. Well, you certainly tried to put yourself in a favorable light. So now you tell me why you shouldn't go through that door to jail for a few days. Did you go to jail? No, you're given a ticket, weren't you?
Yeah, she went to jail for 2 days. She has 2 days credit on this file.
So why shouldn't you go for 3 more so you can have your 5 days in for having another theft crime on your record?
Your Honor, she does have 2 children at home. She,
What a great example.
while we've had a few
A thief.
incidences here, Your Honor, I believe that the CST counseling that is being recommended from probation would take care of those circumstances in a way that may be better than any sort of in custody time. Your Honor, fines and costs are obviously going to be a big thing as well. She's getting hit financially for this sort of charge. Based on what I see in the report, the R&O is something that is relatively straightforward. It sounds like she does acknowledge that she did resist the police. I know the retail fraud is a concern here with the court, but again, that CST class does, I believe, quell most of the concerns that the court may have about her behavior.
Did you not have the CST class back in 2011?
Your Honor, that was some time ago. She was a juvenile, as the court has indicated on many sentences. It takes a while for a person's brain to develop.
Well, apparently yours is still. You're a thief. Why you feel you're entitled to take whatever you want out of a store? Skip, scan, or attempt to, whatever. You tried to leave that store without paying the bill, and you had other people doing it with you too. And you are a thief. And I don't doubt that you did this on a prior occasions. You just didn't get caught. Maybe you should own a small business and have to rely on the income that that one generates from owning a business, and then have people, and then you get to enjoy the lost fruits of their labor. You can't feed your family, can't send your kids to school, you can't put a roof over your house. Or maybe you think because it's Target, it's big enough that you just think you can take from them. And then you lie. You don't tell the truth. Maybe putting you in jail would send a message to your children that stealing is wrong. And you receive benefits from the taxpayers of the state. So you stick it to the taxpayers twice. You take money that is offered, assist with, because of one being poor, which is a noble cause by a state to do that, for those that should and qualify for that. But then you stick it to them again by making the prices for what they have to pay higher because you steal. You're a thief. Good one. I don't know how the hell you job. What the hell were you doing with a firearm in your car back in 21?
I had just purchased it, and then I was
What the
moving.
hell do you need a gun for?
I was moving
Hunter?
houses, and it was in the back of my trunk. And when I did get pulled over, I did let the police know.
What'd you do? Get it at Showcase?
No,
No. So we'll do this. With regard to count 1, 12 months supervised probation. So you have me for a whole 12 months. Boy, won't this be a fun time. With regard to the fines on that, since you didn't tell the truth, $400 fines and costs, 75, 50, 50. Random and refrains. Ms. Slaughter will explain that to you. If you were drug tested today, how would you test?
Negative for everything.
Very well. Also, see, well, I'm going to put that in count 2. So alternative is going to be the 363. So I have a whole year of jail to utilize. You're supposed to go to counseling. I'm going to put that under count 1, CST counseling for theft offenders, how to be a better mom, and whatever other assessment they can find in order to treat you so you don't come back through. With regard to count 2, 2 days as well for 2 days credit. It's also common. 12-month supervised probation, theft offenders program, random and refrains, alternative 91. Should you violate the terms of your probation, that means firearms, no drugs, no stealing, no violation of the public good. Should you do any of those, then we will just work with the alternative. Do you have any questions while you're here?
No.
Very well.
Excuse me, Your Honor. Count 2, are there any fines and costs?
Yes, there's $500 fines and costs. She's a key.
Your Honor, if the court could keep it at 250 at least here, we already have 12 months probation. She's gonna have $30 a month while she's on probation to pay. Yep. Is it 500 or 250?
500. But there's the other 400 for count 1. She would have told the truth, would have been a lot different turnout. But since she didn't, and she's a thief, she gets 12 months of this court.
Since she didn't, and she's a thief, he gets 12 months. But ladies and gentlemen, from Saginaw to Wisconsin, or Michigan to Wisconsin rather, this is a little bit of a deep dive with Taylor Shabusiness. Some of you may know the name, some of you may not. There were some big events that happened this week, and it all starts right now.
Startling attack in a Brown County courtroom caught on video. Green Bay murder suspect Taylor Shabusiness attacked her own defense attorney today.
And just minutes after the attack, her lawyer told the judge he plans to withdraw from the case. The 25-year-old is charged with murder and dismemberment of Shad Therian last February. The attack startled everyone in the courtroom as Shabusiness stood up, still handcuffed, and lunged at her attorney Quinn Jolly. Shabusiness was quickly subdued as the court called for backup. The attack happened roughly 10 minutes into what was supposed to be another competency hearing for Shabusiness. The judge expects to hear expert testimony today, but the defense asked for more time to file a report, saying one of the experts wasn't available today. Judge Thomas Walsh not happy with that information.
Quite frankly, it seems as if this has laid out the process of simply getting an adjournment of the trial, because the idea that all of this occurred yesterday when the report was due Friday is difficult to comprehend.
Despite the attack, Judge Walsh did reschedule Shabusiness's competency hearing for March 6th. Her murder trial has been pushed back to May 15th.
A woman sentenced today to life in prison without the possibility of parole. 25-year-old Taylor Shabusiness was convicted of charges for the murder and dismemberment and sexual assault of Shad Therian in Green Bay back in 2022. Months later, you'll remember this video. Shabusiness went viral after courtroom video captured her attacking her own attorney during a hearing. The case has taken so many twists and turns over 19 months. On Monday, Shabusiness's current attorney, Christopher Freilich, withdrew a request to postpone the sentencing.
We are learning new developments this morning connected to a convicted killer, Taylor Shabusiness. You watched her murder trial right here on Court TV when she was convicted of dismembering and severing the head of her lover, Shad Therian. Now, we are understanding that she's going to be back in court because she allegedly attacked a corrections officer. Back in July, Shabusiness got into a scuffle during a visit to the prison's medical office. According to the criminal complaint, the guard was hit in the head with a medical tray and sustained bruised ribs and was exposed to pepper spray. Shabusiness was apparently laughing during the incident. Taylor Shabusiness has a preliminary hearing scheduled for February 7th.
All right, the court will call 24 CF 1048, State of Wisconsin versus Taylor Shabusiness. Appearances.
Gordon Leach for the state.
Taylor Shabusiness is personally present. She is in custody with Attorney Curtis Jelka.
All right, this matter is set for a preliminary hearing today. Mr. Jelka, what's the status?
Your Honor, my understanding is we are proceeding.
All right. Mr. Leach.
Your Honor, I'm just checking in on the status of my officer. I expected her to be here, but I'm also having connectivity problems here. I might need to run upstairs and see if she may be upstairs. If I can have him.
Sure.
And Judge, it sounds like just one witness. We're asking for sequestration, but that may be a moot point.
All right.
It is one witness, Your Honor.
We're off the record. Ms. Shabusiness is now down in the jail. She's appearing by Zoom in the jail. The last time we report, there was a commotion. She had yelled, stood up. She was then physically detained, moved out of the court, and moved down to the jail. It appeared, I didn't see exactly what happened with it. It appeared that she had tried to get at her attorney. And so the court does now find that Ms. Shabusiness has waived her right to be personally present given the outburst. Are we prepared to proceed with the preliminary hearing?
Yes, Your Honor.
Your Honor, I'm requesting to withdraw at this point in time.
Your request is denied for this hearing. State versus Case 175 was second one. You can continue for this hearing, and then you can withdraw after that.
Okay.
Thank you, Your Honor. The state does call Detective Milan.
Do you solemnly swear that the testimony you shall give in this matter before the court is truth, the whole truth, and nothing but the truth, so help you God?
I do.
Ms. Milan, if you want to state your name and spell your last name. I'm sorry, Detective Milan. If you want to state your name and spell your last name for the record.
Christina Milan. Christina's with a K. Milan is M-E-I-L-A-H-N.
Mr. Leach, go ahead.
Detective Milan, where do you work?
I'm a detective with the City of Fond du Lac Police Department.
As part of your duties as a detective, do you on occasion review the reports of other officers?
I do.
And as well as, do you also review sworn complaints that are filed with the courts?
I do.
And are those complaints, what do they typically rely upon?
They rely upon the reports of the officers that respond to different complaints or incidents within the City of Fond du Lac. They also rely upon witness statements, videos, any other evidence that is brought to the attention of the officers or investigators as they're putting together their case.
Now, do you know an officer, Lindsay Lutke?
I do.
And have you reviewed reports of Officer Lutke in the past?
I have.
And do you find that Officer Lutke is accurate and truthful in the reports that she makes?
I do.
Now, do you know whether Officer Lutke investigated an incident at the Tachita Correctional Institution that occurred on July 24th, 2024?
I do.
And how do you know that?
I reviewed the criminal complaint for that matter.
And was that a sworn complaint by your agency?
Yes.
Whose report did that rely upon?
Officer Lutke's.
Thank you. Can you tell us what who's involved in the incident on July 24th of 2020?
Objection, Your Honor.
Oh, it's the objection.
Well, I know hearsay is admissible at preliminary hearings. I don't believe that there are any personal observations from Detective Milan involved, so she's in essence a conduit for hearsay and doesn't have any information of her own to benefit the court.
Mr. Reach.
Your Honor, as Attorney Joko pointed out, the court can rely upon hearsay. Detective Milan has testified that she has reviewed the sworn complaint in this matter that does rely upon Officer Lutke. Detective Milan further has testified that Officer Lutke is reliable or trustworthy in the reports of the investigations that she reports upon. And I believe that would give it sufficient reliability for purposes of the preliminary hearing today.
Overruled. You can answer the question.
Can you repeat the question, please?
Yes, thank you. Do you know who was identified as being involved in the incident that Officer Lutke reported on that occurred on July 24, 2024 at the Tachita Correctional Institution?
Yes, it was an inmate at Tachita Correctional Institute, which is located in the city of Fond du Lac, county of Fond du Lac, state of Wisconsin, by the name of Taylor Shabusiness.
All right, and are you familiar with Taylor Shabusiness at all?
Not from personal interactions. I have reviewed her photo spread through the Department of Corrections for inmates, which provides her physical appearance.
All right, do you find that reliable?
I do. I use it often.
And can you, did you see Ms. Shabusiness here in court at all today?
I did.
All right, when was that?
Earlier around 8:30 this morning.
All right, and do you see her or her represented in the courtroom today?
I did see her represented in the courtroom today.
All right, and do you see her now?
Yes, she's on the video screen to my right.
And what is she generally wearing? You just described.
Orange jumpsuit.
Your Honor, I'd ask the record to reflect Detective Milan has identified the defendant in this matter.
Mr. Joko.
Your Honor, no objection, subject to cross.
The record will so reflect.
Detective Milan, what did Officer Lutke report occurred at Tachita on July 24th of 2024 involving Ms. Shabusiness?
Taylor had indicated that there was a staple in her arm and a request was put in for a nurse to remove it. One of the correctional officers at Tachita, a female sergeant, was tasked with bringing Taylor down to the nurse's office so the nurse could remove that staple. While in the nurse's office, Taylor began giggling, and then a short time later, when the nurse was in the process of removing the staple with the tweezers, Taylor lunged initially at the nurse. Then the sergeant pushed the nurse out of the way and began to try to gain control of Taylor to get the nurse out of the way. And in the process of that, metal tray from the nurse's room was grabbed by Taylor. The correctional officer believes she was struck in the head by that, does not believe she was concussed. but then reported in the course of struggling to get Taylor under control, received bruising to her ribs and pain in her arm.
And did the, was it a sergeant, I believe you said?
A female sergeant, yes.
Thank you. Did the female sergeant, did she report having any pain from being hit in the head?
She reported having pain from the entire incident and did seek medical treatment for potential injuries.
And did the sergeant say whether she had consented to Ms. Shabusiness injuring her in that fashion?
She indicated she did not consent to that occurring.
No further questions, Your Honor. Mr. Jelka.
Thank you. Officer, Detective, did you review the video in this case?
I did not.
So you're solely basing your testimony on the criminal complaint today, is that correct?
That is correct.
So, just to review, the moment prior to the alleged lunge, there were 3 people in the room? Is that your understanding?
From the criminal complaint, that is my understanding.
Okay. And are you familiar with Tachita, whether they have any process for identifying or making sure they have the right patient in the room at any given moment?
I'm not overly familiar with their procedures, but I have responded there for numerous incidents, and most inmates do have a number or a system for identifying them.
But you don't know if Ms. Shabusiness was wearing any such identifier that day, correct?
I don't know that.
Okay. So the moment prior to what you described as a lunge, where were the parties positioned, if you know?
I can't say other than the nurse was in the process of taking the staple out at the time, so within close enough proximity to do that.
Okay. And just to take it a moment further, Ms. Shabusiness allegedly lunged at the nurse?
Lunged or caused some motion in which the sergeant was concerned for the nurse's safety.
Okay. And then did the sergeant effectively intercept her, or did she actually make contact with the nurse, if you know?
I know the nurse was asked if she was hurt. I'm not sure if it was direct contact, incidental contact, but there was questions of whether the nurse was injured.
Now, the person described as the victim in the complaint, that would have been the guard, is that correct?
The female sergeant, yes.
Okay. And she indicated the number of injuries, including pain in her head, but short of a concussion, bruised ribs, and a hurt arm, is that correct?
Correct.
Okay. Did she attribute how her ribs had been bruised or her arm had been hurt?
It was not stated in the criminal complaint if she mentioned that.
Okay. But the head injury, I guess, would be related to a tray hitting her?
It was inferred that, yes.
Okay. You don't know anything about the specifics of that tray, correct?
I don't know any specifics other than the nursing trays that are used by nurses.
Okay. Was there any exclamation or sound that Ms. Shabusiness made before she allegedly lunged?
The only thing that was discussed was like some giggling or some laughing that preceded that. The exact timing of that proceeding was not outlined in the criminal complaint.
Okay. So you identified Ms. Shabusiness as the defendant earlier today, correct?
Yes.
You have no way of identifying her other than the complaint as the person present in the room at the prison, though, correct? You didn't see any video, you weren't there?
I wasn't there, I didn't see that. The sergeant identified her and the nurse identified her from previous contacts.
Okay. Thank you, that's all I have.
Any redirect?
No, Your
Are you gonna step down? Mr. Leach, any other witnesses or evidence?
No, Your
Mr. Jelka, any witnesses or evidence?
No.
All right. Mr. Leach?
Your Honor, without argument, the state asked for finding.
Mr. Jelka?
The judge would just briefly argue the identification. Detective Milan identified Ms. Shabusiness based on booking photos. Doesn't have any personal knowledge of who was present in the room at Tashida, didn't even see the video, so I would move to dismiss, the argument being the identification was inadequate at this time.
The court will find probable cause that a felony was committed and was likely committed by Ms. Shabusiness. The case will be found over to
Judge Nails.
Mr. Leach, do you have any information?
I do, Your Honor. I'm providing a copy to Attorney Joka and to the court.
Mr. Jelka, subject for local tenure, local substitution, do you want to proceed with an arraignment?
Your Honor, that was my understanding for today. I would defer to Ms. Shabusiness if she still wishes to continue with that today.
Ms. Shabusiness, do you want to proceed to an arraignment today?
Yeah.
Yes?
Yeah.
Okay. Go ahead.
Your Honor, I have received the information. The charges appear to be identical to the criminal complaint. Would waive its formal reading and subject to 10 days to decide whether to substitute would enter not guilty pleas.
Not guilty pleas but enter. This matter will be scheduled moving forward. Anything else from the state?
No, Your Honor.
Mr. Jelka, anything else?
No, thank you.
Case adjourned. Thank you.
And I'm sure there will be a lot more to that story. But next, I have a little bit of a special appearance from one of my favorite judges. And it's just a little something I wanted to throw in here and review because I'll be honest, I haven't seen this one, so I want to watch it. We're all watching it together. And it starts right now. This is Judge Olsaver. Judge Olsaver.
Okay, the gentleman at Macomb County Jail, you're Mr. Stover?
Yes, Your Honor. Good morning. Thank you for having me.
Okay, 1 second. This is file 21-20605-FC, People versus John Mitchell Stover. We are here today for arraignment on several bench warrants, and we are proceeding today by video conference. Sir, you are John Mitchell Stover, correct?
Yes, Your Honor, I am.
Have you received copies of the request and warrant for probation violation in your file?
I do not have the copy of the paperwork. The only thing that I had been given was hold orders.
Okay. How long, Mr. Stover, are you going to be at the Macomb County Jail? Do you know?
Your Honor, with all due respect and no disrespect, I do believe this matter is going to be here. I'm going to be here at least for over a year.
Okay, I'm just trying to determine whether we can send copies of your warrants to you at the Macomb County Jail. So if you're going to be there for a while, we can mail them to you there.
Okay.
In the meantime, I will tell you that there are 4 warrants for alleged probation violations in your file here. The first is filed on February 28th, 2023. That warrant alleges that you violated the terms of your probation by assaulting your girlfriend, Crystal Fenderson, by pushing her with your chest, getting on top of her and choking her while biting her left cheek, then grabbing her cell phone, throwing it and breaking it so she could not call 911, then fleeing the scene, and your whereabouts were unknown. The second warrant is dated April 3rd, 2023, and that alleges that you violated the conditions of your probation by sexually assaulting your girlfriend, Crystal Fenderson, forcing anal sex on her while having your arm around her neck in a choking manner. The third warrant is dated July 28th, 2023, and it alleges that you violated the terms of your probation by assaulting your girlfriend, Crystal Fenderson, striking her with a closed fist to her left eye. The fourth warrant is dated July 28th, 2023, and alleges that you violated the terms of your probation by physically and sexually assaulting Crystal Fenderson, pulling her hair, biting her hand to keep her from defending herself, then using an extension cord attempting to choke her. He then got her ice to reduce the swelling in her head, and she suffered, and she refused, and he tried to force it on her. It also alleges that you sexually assaulted her on that date as well. You were, in this case, convicted of assault with intent to do great bodily harm less than murder. The maximum possible penalty for that offense is up to 10 years in prison. You do have the right to be represented by an attorney here today and at any other proceedings we have regarding this matter. If you're not able to afford an attorney, you can tell me that and I'll appoint one for you at public expense. Do you understand that?
Yes, Your Honor, I do.
Do you want to be represented by an attorney?
Yes, I do.
Do you have the ability to pay for your own attorney?
I do not at this time.
Okay. In just a moment, I'm going to deal with one other case first, and then I'll put you in a breakout session with someone from the public defender's office.
And Your Honor, if I could have the paperwork, please.
Yeah, in the meantime, we will send that to you.
If I may, Your Honor, is Miss Underwood going to be my attorney in this matter?
Yes, she is the person from the public defender's office that handles probation violations.
With all due respect, I'm going to recuse her now.
You don't have an option to recuse her. I can appoint the public defender's office if you've asked for your attorney, but you don't get to choose who your public defender is.
Well, there's just conflict of interest, Your Honor. I don't need biasness.
I'm not aware of any conflict. If there is a conflict of interest, then the public defender's office would appoint a special public defender for you, which I believe has happened with respect to the underlying case back when we originally went through this. So I don't know, Ms. Underwood, you might want to check into that if we're going to need to appoint a special public defender for him. I think that was previously a conflict of some kind.
Yes, it was, Your Honor. It was James Daly at that time.
What is the name of this individual, Your Honor?
It is John Mitchell Stover, Stover.
Thank you.
And Your Honor, if I may, address bond at this time.
All right, let me work out the attorney issue because you requested to be represented by an attorney.
Your Honor, we had this case back in 2021. It's my understanding that Mr. Malero had the case and it was conflicted out. And Daly's, our last note is that on July 22nd, 2021, Mr. Daly took the case.
Okay.
If I may, Your Honor, back at that time, I did not have an attorney. It was pro se. I did not have one Sam Malaro, and the situation was, it was unconstitutional from the beginning because
Mr. Stover, Mr. Stover, please stop, because we're getting into things that have no relevance to the current issues. You've requested an attorney. Mr. Stover, don't interrupt me. You have requested an attorney. We're going to need to appoint someone, a special public defender, because there's a conflict in the public defender's office. We're not going to be able to do that today. So what I'm going to do is adjourn this until next week. I'm going to enter a not guilty plea for you on all of the allegations, and I'll adjourn this to next week. In the meantime, the public defender's office will go through the process of appointing a special public defender so that you can be represented at that time.
yes, I understand that, Your Honor. I just want the record to reflect very clearly. I was pro se, and you guys gave me an attorney unlawfully.
All right,
you guys, because
Mr. Stover, I'm not going to argue. I'm not going to argue with you today. The hearing is adjourned until next week, April 9th at 8:15.
I've asked you, Your Honor, to address bond.
What would you like to say about bond?
I'm asking for a nominal bond.
You have bonds on all of the cases, so you would be getting credit.
I don't, that's what I'm saying. I don't know of any of the bond amounts or anything. That's why it said it was for the amount of the actual case file, which was $13.98 or $68 or something of that nature, I believe.
Okay, so on the July 28, 2023 warrant, you have no bond. On the on both of the July 28, 2023 warrants, you have no bond. On the April 3rd, 2023 warrant, you have no bond. On the February 28, 2023 warrant, you have a bond of $1,398 cash.
So just to reflect this clearly, you're saying that I'm getting credit for being here thus far. I've been locked up since February 1st, sir.
Correct. You'll be getting credit because you haven't posted bond on any of those warrants in this case.
Thank you.
All right. You can let them know that you're done with court for today.
Thank you very much. God bless you.
And God bless you. God bless everyone. Ladies and gentlemen, we've come down to the last section of our presentation for the afternoon. And this is going to be a long one from Thurston County, ladies and gentlemen, involving a plaintiff who's angry with her father, bailing her husband out of jail. It's a PPO. It's Wilcox. It all starts right now.
So, Jason O'Brien, you need to unmute. So I'm looking for your, did he tell you, is he off dealing with his other case?
He just got the verdict in, and he's coming on right now, I believe.
So I think probably we're going to continue the O'Brien matter here. We're going to set a new court date because
Ma'am.
realistically, we're not going to get to things. Oh, he's back. All right. Mr. Johnson, you with us?
Oh, hello, Your Honor. Yes, I am.
All right. Are you free from the other court?
Yes, I am, Your Honor. Thank you.
All right.
Appreciate your patience.
Okay, so we'll take your matter up now. Then if Brooke O'Brien you are there. Jason O'Brien, we have you. And now we have Mr. Johnson, who's representing Mr. O'Brien. And 2532 is our case. You don't have to stay there, Ms. Paris, if you don't want. And let me get the documents up before me. As you see, I'm going to be looking back and forth as I've got an electronic file, and I am listening, but looking at what's been filed. Thank you. Let's see. All right. There's a lot of information filed, and I had an opportunity to review it all. So let me put Ms. O'Brien, have you raise your right hand. Brooke O'Brien, you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. And then Jason O'Brien, raise your right hand with me. Swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. So I'm going to start out here. I've had an opportunity, as I said, to review. There's lots of information provided on all sides. And Mr. Johnson is representing Mr. O'Brien, and he's going to have the opportunity to ask questions of Ms. O'Brien and to present the case for Mr. O'Brien. So first off, Ms. O'Brien, then as I said, I've looked at everything. And let me just kind of open something up here again. So I have it before me. There it is. Before I allow Mr. Johnson to ask any questions, what would you like to say that you haven't already put into evidence, or something you want to focus in on? Or
Your Honor, I'm just here again today to request a 1-year protection order, sadly, against my father. My father's harassed and threatened and sabotaged a lot of things regarding a DV situation as well. That was submitted as well, that he bailed out my husband in a DV situation. The mental and verbal abuse has continued into my adulthood, as I've submitted that as well. I've endured this behavior for far too long, which is why I'm here today. My father's lied in his declaration about his Facebook accounts. I've proved that in exhibits that he's perjured himself. He's used multiple Facebook accounts to harass and
you're
reach
referring to your
out.
second petition, your second response? Is that what you're referring to, those exhibits?
Well, I wasn't allowed to respond to any other exhibits prior last court date.
I have the second declaration of petitioner.
Then yes, then that was submitted.
Okay.
That is what I'm talking
Those
about.
pictures that are appended to that, is that what you're talking about, or?
Yes.
Okay.
And then on top of this, he's used those accounts for years. My father's sister, Natasha, also lied in her declaration by falsely stating that I obtained and shared content without her knowledge or permission. These were messages clearly Natasha sent to me by herself, also proven in the exhibits I provided. Natasha's no longer here with us as she has passed away. So having her to deal with this on her deathbed is quite concerning in general for her to write anything as she was medicated on morphine to pass peacefully. I believe my request for protection rises to a level of unlawful harassment, and I believe my father needs to be accountable for his behaviors that he is all of his witnesses attested to in their declarations. I believe he also, the only way that this will stop and this behavior will stop progressively will be because of legal repercussions. Thank you for your time.
So you're asking for an order that would do what? What would you want?
Protect me from all the things that I've submitted to the courts, ma'am.
So what does that mean? No contact of any kind with your father, not allow him to contact you through family, through friends, through social media, to stay
Correct.
away from you, a geographical distance?
Yes.
Just looking at your petition here to be clear what you're asking for. Let's see, you said no harm to you, no contact with you, no stalking, stay 1,000 feet away from your person, your residence, school or daycare. I didn't see any kid. Yes, of the
Okay, her name's Grace
child.
Novak, and yes, I want her involved as well for a year.
And all right, so all of those things you asked in your petition, that's what you're asking for.
Yes, Your Honor.
All right. Let me just kind of review again to see if I have any particular question. Well, Mr. Johnson, why don't you go ahead? Do you have any questions of Ms. O'Brien?
Yes, Ms. O'Brien, isn't it true that you received financial assistance from your husband as recently as January?
How is my husband allowed or even able to give me financial assistance?
Not your husband, I'm sorry, I misspoke. Your father. Your father provided financial assistance to you and your husband as recently as January, true?
Since January, because we worked for him in his construction company, yes. But that was also paid wages that were earned.
So those Venmo transactions, $400 here,
Which are directed
cetera,
towards
those-
Dustin Kendrick and as well as the money that's obtained by my father for work has nothing to do with the harassment. So let's move on from that.
Well, I think it's telling. You were asking your father for money repeatedly as recently as a week before filing this order. Isn't that true?
That's untrue, actually.
Well, we have the
Yeah, a week prior to my domestic violence situation, so not technically the restraining order.
okay, but your father was Venmoing you money, Venmoing your husband at your request. True?
Untrue. It was for paid wages that were worked on his job site.
I see. And so the paid wages were in irregular increments, like $400 here, $50 there, another
Financial
$75.
situations are none of your concern, actually.
So Ms. O'Brien, let the question be finished and then answer it as best you can. So Mr. Johnson, why don't you rephrase the question? And then Ms. O'Brien, then you answer the question.
It was pretty straightforward the first time, Your Honor.
I want to hear it because they were talking over each other. So Mr. Johnson, what's the question again?
Thank you. So it's your contention here today that each and every time that Mr. O'Brien was Venmoing and sending cash money to you and your husband, it was strictly in compensation for wages.
Correct, and it's an ex-husband, thank you.
Okay. And so over the course of the previous, and that was the last transaction was about a week before you filed this restraining order, isn't that true?
To Dustin Kendrick, yes.
Okay. And that was while the two of you were still together prior to the domestic violence situation.
Yes.
And the domestic violence situation that you're referring to throughout is Justin and yourself. Isn't that right?
Sorry,
Yes,
I couldn't hear that,
yes.
Mr. Johnson. What was the question?
The domestic violence situation that you've referred to numerous occasions is the domestic violence situation involving your husband and you, true?
Yes, if you read the declarations, that would be true.
And Mr. O'Brien, my client, the respondent, was not present during any domestic violence situation between you and your husband that Mr. Kendrick, your husband, was arrested for, true?
Yes, true. It was midnight. I don't think anyone
Okay.
should be at my house at midnight, but yes.
Got it. So at midnight, you and your husband get into some sort of a domestic violence
Let's pause
situation.
for a second.
Ms. O'Brien, you need a what? What are you asking for?
To get into details about the domestic violence is pretty triggering for me, and that's not to be discussed under what is here today. It's harassment. So I don't like to discuss further into my domestic violence situation. Besides that, this is added up to my dad bailing him out of jail.
That is the
Okay,
only
you're saying
parts of that.
that it's not relevant for Mr. Johnson to ask about what happened between you and Dustin Kendrick.
Yes, it's none of his concern nor his
Okay.
business.
Well, a lot of things start to open up when we come to court, but I'm going to turn to Mr. Johnson about that. Mr. Johnson, maybe you can tell me where you're headed so I can make a decision about that objection.
Thank you, Your Honor. Your Honor, I think I have the answers that I was looking for already, so I can move to the next series of
All right.
questions.
Okay.
Thank you. So your husband is your direct first cousin, isn't that true?
If that's what it states in the thing and what he wanted to pursue, yeah. If that's what you guys.
He's the son of Mr. O'Brien's sister, isn't that right?
Yes.
And Mr. O'Brien's sister was dying of brain cancer throughout this situation. True?
Lung cancer. Lung cancer.
Lung cancer, I'm sorry.
That's kind of disregarding and sad that you guys couldn't get that right. Rest in peace, Natasha.
Yes, may she rest in peace. It was lung cancer. I apologize. So she was dying of lung cancer.
Correct.
And let me back up a second. So by your own testimony, you were working for your father. You were in a relationship, father-daughter relationship with your father, up to the point that you and your husband get involved in a domestic violence situation at midnight. Is that right?
Yes, but it's also pursued into my dad as a pattern behavior that this has not happened just more than once, which has been submitted as well in my declarations.
Got it. So you were very upset that you found out through a third party planning to bail your husband, your cousin, his nephew out of jail. True?
Wouldn't you be upset if your father didn't believe that's in court record that happened and he decided to bail someone out in regards of strangulation his own daughter and putting his hands on me? I think anybody would be upset regarding that.
Ms. O'Brien, this is a difficult situation for everyone. Asking the attorneys questions or what they would feel is not relevant. I'll ask you to answer questions that you can. All right, so
which I am doing my best
make
to
extra
do.
comments. Don't ask questions of the attorney and how they would feel about something. Simply answer the question that they pose. So, Mr. Johnson.
Thank you, Honor. Mr. Bryan, it's also possible that your father wanted to give his dying sister the gift of having face-to-face contact with her son before she passed. True?
I wasn't knowledgeable about that, so that's really for him to
speculation,
decide.
Mr. Johnson. I don't require Ms. O'Brien to
That's
answer
called a guilt
a
trip.
question that she has to divine what another person is thinking.
Okay.
So you don't have to answer that
So
question.
fair enough. So the reason I ask you that, Ms. O'Brien, is because it sounds like you're speculating on what your father's reason is for bailing your husband, cousin out of jail.
So what would you like me to respond to that?
True or false?
Yeah, I'm very angry that he did that because I'm his daughter.
So you speculated as
I did
to
not
what
speculate anything.
his intention was in bailing his nephew out of jail.
Oh yes, let me
True?
respond to that. Yes. His intentions were not pure. I've received text. Please don't interrupt me. I've received text from Natasha, it's being sent to me that he wishes I was dead and hung, and that he wishes I was stoned to death and beaten to death. And I think that's suffice and sufficient enough to why we're here today, of why I don't want any contact with my own father, because as a mother of myself, I would never say anything about my children that way. So let's touch there.
Ms. O'Brien, You included the third-party text that you received in your original petition.
Third-party text in regarding to what?
What you just stated, that he had said some
which was
ugly things.
Yes. So why is that acceptable for anybody to tell that to anybody?
Ma'am,
regarding-
you included those texts
Yes, I did.
that you received somehow from third parties in your original petition, isn't that right?
I received them because she sent them to me.
You included them in your temporary, in your request for a temporary order, true?
True.
And you were denied that temporary order, weren't you?
This got continued. It wasn't
No,
denied,
you
it
were-
was continued.
No, you were
I don't think we
denied.
have to parse that. We're at the hearing to determine if an order will be issued. And so I do see
So
that
let's
that
get-
is part of the evidence, and we're going to talk about it all. So, Mr. Johnson, why don't you move forward from what happened about whether a temporary order was issued or not? And let's get to the meat of this, whether the court should or shouldn't issue this order.
Thank you, Your Honor. Hold on one second. I'm sorry. Computer just froze on me. Let me. So it is accurate that you received tens of thousands of dollars of financial support from your husband in the year leading up to you requesting this order, or from your father.
Negative.
Thanks.
Tens and thousands of dollars seems pretty absurd to me.
Okay. Received.
So once you get
almost-
those numbers, maybe you can put that
you
on
received-
paper.
Look, this isn't an argument.
It's not an
Yeah.
argument, but we
This
are
is-
here in court today
So,
to
Ms.
decipher.
O'Brien,
what's
just
going on.
slow down, Mr. Johnson, slow down. So, Mr. Johnson asked if you received tens of thousands of
No.
dollars from your father, and what is your answer?
False. No.
Okay, so Mr. Johnson,
Thank you. But we've provided to the court the specific transactions for just 1 month, and it totals $2,850. You saw that, correct?
Correct. And that's not, it's for paid wages.
So
No, let me talk if you want an answer, please. It's for.
it was a yes or no question, ma'am. It was a yes or no question. Here's the next question.
Wonderful.
You're claiming that you worked for your father. Can you tell me what job you did working for your father?
It's under IQ construction and he doesn't actually have workman's comp. So it was to help him do dump runs. So
I
he didn't
see.
have to hire somebody to do so.
So it's your contention that you
And this isn't
did-
about money. This is about the harassment.
It's your contention that you did dump runs totaling almost $3,000 the last month
And
prior
labor.
to filing.
And labor, yes.
So this is actually the second time you filed a petition against your father, isn't that true?
This is the first time for a no contact order.
Okay. You filed this
Where did you
separate
find the second time?
Here, let me come back to that. I'll get you the date. Hold on 1 second. Let me just go to the next question. So you also sent text messages to your father that were, I guess we could characterize.
your feed kind of broke up there, Mr. Johnson. Say that again.
You also sent text messages to your father that would be characterized as ugly. Isn't that right?
Yeah, but this is the harassment on him, not me, because I do stand up for myself and what's wrong and what's right. I can be ugly if you are ugly towards me, but at this point, this is towards him.
Well, it would
This
be
is about
relevant
him
for the
harassing.
court to hear your comments to Jason O'Brien, if there within a particular amount of time here. So Mr. Johnson, go ahead.
You've used the F word toward him in text.
Oh. Do you want a yes or no to that?
Of course, I want a yes.
Well, yes, I have, as he told me he wanted me dead. So, I mean, why don't you
So
stand up for yourself?
you're characterizing the conversation where
Where's the proof in these ugly messages
he's
that have been submitted to the court?
you're
So just answer the questions, Ms. O'Brien, if you can. And that's the
Well, I said
evidence,
yes the
that's
first.
his testimony. So, Mr. Johnson?
Your Honor, you're characterizing the argument that you and your father had about he perceived that you were being dishonest, and he said, "Or demised little child."
Demised little child. I'm an adult. So we can kind of
You were
correct that.
You were offended that
You're breaking up. It's not
Mr.
quite
Johnson,
clear.
You were
your connection
offended.
is not good.
You here. Let me try something different, Your Honor. Hold on a second.
Charger, type C.
Okay, can you hear me better now, Your Honor?
Yes, go ahead.
Okay. You were offended that he referred to you as little child?
What's the response in that text?
Well, the response in that text is telling him to F-U-C-K, etc. Right? So that means you were offended,
So
true?
where's the evidence of these messages? Because that's not been submitted.
Let me worry about the evidence, okay?
Okay.
I'm just simply
That's
asking.
So,
crazy.
Ms. O'Brien, evidence is testimony. Answer the questions as best you can. This is not an argument you're having with Mr. Johnson. I'm trying to get evidence so I can determine what to do here. And you're arguing with the attorney isn't helping. So please
yes, I
just
was
answer
offended.
the questions.
So, ma'am, the earlier protection order was filed and denied on December 10th, 2018. True?
Yes.
Okay. So, all right. So you read the declaration from Natasha saying that that she did not directly send you the communication between her and Mr. O'Brien. True?
I don't know about that one.
You read Natasha's declaration?
Yes, and it's false.
Okay. And so and Natasha passed away within the last week?
Yes.
So the text that he sent you about the little child, he said in that text, your lies have gone far enough. Good luck. True?
Untrue.
Well, that's what the text reads, right? You lied. I think there's a typo instead of lies. It's lied.
I was able to prove it. It was perjured.
You lied, have gone far enough. Good luck. True?
Untrue.
So, I guess I'm not clear on what part you're talking about was perjured. One of your primary claims is that he made the little child comment. Are you now saying that he did not make that comment?
Yes, he did. You asked if it
Okay.
was offensive to me, and I said
That's-
yes.
That's right, but now you're saying it's perjured or something. I am not following you.
The declaration of Natasha's is.
Okay,
Because-
but we're now turning to the text. This is the only text that was sent directly to you that is part of the evidence of this case. And that text continues with more writing from Mr. O'Brien, and it says, "You lied, have gone far enough, good luck," right?
Right.
So he's upset about what he perceives. I'm not asking you whether you're lying or not. He's asking he's responding to what he perceives is lying by you, right?
Right.
And you submitted a response to that, and the response was, go fuck yourself. True?
True.
You were angry with him, right?
The words are the words, yes.
Yeah. But they're not the words of someone who's afraid of someone, are they?
I'm not afraid of my own father, but I am, this is for me to elaborate on. So excuse that. Yes, to your answer. I'm not scared of my father. Go ahead.
Go ahead. That's fine.
I'm not scared of my father. I'm not scared of him, but at the same time, what he's doing is wrong. And how he talks to people is wrong.
Got it. So you brought the petition to punish him. Is that right?
To enlighten him about his behavior, yes.
Okay. So you're upset that he bailed your cousin out of jail. That's what you're upset about, right?
Yes.
Okay.
I don't trust him in his actions either.
Got it. So you're not under substantial emotional distress because he's called you little child, right?
That's the least of my concerns. I'm
Okay.
under mental stress and emotional stress because of what he's pursued in text messages that have been submitted of evidence to the court that he wishes I was dead and stoned to death. And that's pretty mentally destroying for anybody, if you ask me.
Okay. So I'm going to object to facts not in evidence. There's no evidence that Mr. O'Brien said that he wanted her dead or that he wanted her stoned to death. It's just the record is what the record is, Your Honor.
Which is a pattern of his behaviors. He was harassing me prior to him even
So, Your Honor, I'd like
bailing me out of jail.
I'd like a ruling on my objection. I'm objecting facts not in evidence.
Right. I am looking at petitioner's exhibit and I'm looking at a text message that, where was that? That didn't say, it said, I just wish Destin would get smart, walk away from her and leave her hanging. Brooke needs to fucking just be hung, beaten, but still live, but be taught, spelled T-O-U-G-H-T, a lesson. That's what I'm looking at. So is that?
That is what I referred to.
Yeah. Okay. So Mr. Johnson?
Okay. So it doesn't say anything about you being stoned to death.
But I think the other sufficient evidence is enough to make sure that's
Ma'am,
harmful
it's a yes
to someone.
or a no. It does not say that you're to be stoned to death, right?
Yeah. Yes,
Doesn't-
that's what was read.
Okay. Doesn't even say that you're to be killed, does it?
Beaten to death? Is that what I heard? Beat?
But still live, ma'am.
But
but
still
still-
live. Wow, that's real refreshing.
Fine. And it was a message that he sent not to you, but to his own sister, right?
And there's also more evidence that was that does say stoned to death and different evidence that has been submitted. So maybe we can read through that too.
Has not been submitted, Your Honor. So we because it doesn't exist, frankly. So the text messages, there are lots of text messages where he communicates love and affection to you. Isn't that true?
No.
Your father's never told you he loves you?
Any parent would say I love you at some level or another. Yes.
Okay, so your
That
father
doesn't
has
disregard from the last 3 months of harassment. You can love somebody and it still not work out.
So he was harassing you while you were working for him, and he was paying you. Is that your testimony?
Not while I was working with him and all that, but there's prior to the whole you throwing the money in there as well. This isn't about the money. This is about the harassment.
I think that the last transfer of money was January 28th, right?
Because you don't mix business and pleasure.
Okay. So when Jason was released,
When Dustin was released,
Dustin was released,
Want to make sure your client is still with us. All right.
I am.
Brian.
I'm sorry. I had to walk away, Your Honor, for a moment. Come on back.
Okay.
All right, go ahead,
When
Mr.
Dustin, thank you, Your Honor. When Dustin was released, are you aware that your father took his nephew into his own home?
I'm well aware. My own husband reached.
And are you aware that your father took his nephew to his probation appointment the next day?
As he should.
So let's see. Just going through my notes quickly, Your Honor. Your Honor, I think that's all I have for this witness at this time.
So is Brian, anything else before I turn to Mr. O'Brien?
No.
All right, let me just see if I've got in particular. I don't think I do. So, Mr. Johnson, any evidence to present from your client? Other than, of course, he's in the court.
I don't think it's necessary, Your Honor. Let me just hold on one second.
Give you a moment to review things.
Your Honor, Mr. O'Brien wants to address the court.
All right, so I'll have you pose questions to your client.
Okay. Mr. O'Brien, you've heard the testimony of your daughter. Is it true that the money that you were sending to her husband and her family was compensation for work that they were doing for your business?
Yes and no.
Okay, can you explain? Can you clarify that?
Yes, I can. Thank you for asking. Over the years, I have helped Brooke numerous times with cars, vehicles, schooling, as such as her mother has too at times. There have been there's been many multiple occasions where I've helped her pay her rent, sometimes her bills throughout the years, as such as her mom has too. And but during a lot of the money that I've given has not always been generated from them working for me. It has been because they might have been slow on bills or money might have been coming in a little bit slower, but Dad was there to give them money. When I had the opportunity for them to work, I put them to work when they wanted to work. Hopefully that answers your question.
So let's go to the most recent, let's go to the month leading up to the filing of this petition. It looks like it's almost $3,000. You know if that was for work or that was as a gift? Can you speak to that?
Yes, sir, I can. For that month, yes, it was for work.
Okay. What about prior to that?
A little bit of everything. You know, I would send $50 here, $30 there. You know, if she had worked for me for 4 or 5 hours, I'd pay for that time. Because it was pretty tough for Brooke to find a job because of my granddaughter and stuff. You know, it's tough because of the scheduling on my daughter's and her part. So Brooke would work for me when she could. when she could find time to work for me. And there's times being that she didn't have income coming in that month. So I would help them out with bills.
Got it. So, and what was the relationship like prior to you telling your sister that you were planning to bail your nephew out of jail?
I bailed my nephew out of jail to say goodbye to his mother. I didn't do it despite my daughter, to threaten my daughter in no way. I knew getting him out was going to be a situation, but I took that chance for him to say goodbye to his mom. Now, him ending up back in jail was not my doing.
Okay. So the next question that I have for you is the kind of ugly messages that you sent to your sister about your daughter. And it might be horrifying to the judge to hear a father send a message to his sister saying she deserves to be beat and hung but still live, so that she can learn a lesson. Can you provide some context to the court for that? Because it's kind of a shocking comment, and that alone might, create bias. So I want the court to know what your perspective is on that.
Thank you for asking me that so I can define that statement. In no shape or form would I want anything to happen to my kids, my daughters. I just want my daughter to be held accountable for the lies and the picture that she's painted, and stop playing victim and accept accountability in her life for herself and her self-actions. And I understand what I said was not right, and I'll 100% take accountability for that. I could have rephrased my words in a different manner, but at the time I'm hurt. I'm hurt because of her actions. I didn't raise my child this way, neither did her mother. And so I said some things that I regret, and I do. But at no point ever would I want anything to happen to my kid. Period.
You separated from Brooke's mother when she was about 12?
15.
15, sir.
15.
Yeah.
And you the girls stayed with their mom temporarily, and your boy too, and then you had your son live with you. Is that right?
Yes and no. My daughter Megan lived with my ex Tracy. Brooke at that time was moving out, living with her boyfriend Caleb at the time.
At 15?
I was in Shelton, Washington, doing a job. I came back. I got custody of my son. Well, I got custody as in his mother and I came to a certain agreement that Brandon can come live with me. And ever since then, I've had Brandon since middle school all the way through high school.
Got it. And so were your daughters resentful of the fact that you took your son through high school and Brooke had to go live with a boyfriend?
I can't speak for Brooke's emotional content at that time, but I sensed jealousy, yes, because Brandon is the youngest. And at that point, I was able to give more to Brandon because my life was different. My business was different. My means were different. I sensed that, yeah, and I tried to compensate that by giving them cars, buying them cars, getting them to things, and it just never worked out for me. It's a tough lesson. Tough lesson.
Did you invite Megan to come live with you with her child when she divorced with her husband?
No, I did not. She ended up just showing up, and I opened my house up to her and gave her a place to live.
And she lived with you?
Yes, sir. She did.
So, so it's not. What would you say to their claim that you've been emotionally abusive to the girls?
I wish I could say what I want to say, but I find it to be false. I find it to be false. Not every parent's perfect, nor am I, but it doesn't take away the love I have for them. I never hit them. I never abused them.
Well, that was going to be my next question, because Brooke claims that you were physically abusive to her.
Absolutely not. Absolutely not. Absolutely not.
So, do you want to provide some context on the I'll be your demise, little child? Your lies have gone far enough. You want to provide some context for the court on that statement? That's the only statement
As in the statement, as in I will be your demise.
That whole statement. You can talk about it for the court, please.
What I meant by that comment was I'm tired of her lies. I'm tired of her not accepting accountability in her life for her actions and the decisions in which he's making to continue having to come to me asking for help. When, as a parent, I confront her to try to change the subject. What can we do to prevent you coming to me every month and asking me for help, or every other month? And it goes for all my children, just not Brooke. When I have that parenting talk to them, they get offended because I don't open my, well, I'm just gonna say, because I don't open my wallet as much as I used to. And I want them to be held accountable for their actions. And that's what that meant. I want her to be held accountable.
Did you mean it as a threat?
No, absolutely not, sir. Absolutely not.
Were you upset that your daughter...
Threatening my daughter in any shape or fashion affects my relationship with my grandchildren. I have to be nice to them to have a relationship with my grandchildren.
Have you loved on your grandchildren?
Have I? I'm sorry, sir?
Have you loved on your grandchildren?
My
Yes, he has.
They're my life. I mean, I'm not going to lie. I make a better grandparent than I make a better grandparent than a parent. But my grandkids are my life. I mean, I got a grandkid that was just born 2 weeks ago that I haven't seen because of this.
So,
I can't have it. You know, the people that are suffering are my grandkids. My kids aren't going to sit here and say, hey, look, he's a bad grandparent. They won't say that because I'm an awesome grandparent. They drop off their kids to my house, you know, previous to her filing against me. My grandkid was at my house.
So, Mr. Johnson, why don't you pose some questions?
Thank you, Your Honor. Were you upset that your daughter married her cousin?
Yes, absolutely.
Were you worried about her having children with him?
Yes, absolutely.
I have no more questions for Mr. O'Brien, Your Honor.
Right.
May I speak?
Yes, I was just, give me a moment here as I see if there's something I have a question on. Answer that. So, so Brooke O'Brien, anything in response? You said a lot already and provide a lot of information, but anything additional?
So, you know, I appreciate the financial assistance that my father has helped me with, but this is not what this case is about. He is simply doing his parental responsibilities like most parents do for their children in hard times. That does not excuse the behavior.
What, past the age of 18, Brooke?
Mr. O'Brien,
I'm sorry, Your Honor. I'm sorry, Your Honor.
Hold your peace and let Ms. O'Brien speak. So go ahead. Ms. O'Brien,
I've experienced that does not excuse his behavior or harassment. The emphasis on money is not irrelevant to this case, nor should it affect this. This is about the behavior, which is he's using and makes himself appear to be a supportive father, which he has been financially, like he has said in his statement, and he's thrown money at a lot of things, but it's not ever his money that we wanted. It was him to take us fishing or his time. I also believe my father uses money to attempt to buy the love, but it's not really helpful. And it doesn't fix anything. He bailed out Destin out of jail 2 days after he was served, and he threatened to do so in messages prior to that, which proves he had ill intentions of him getting bailed out. And that's what I have to say about that.
Great. So, Mr. Johnson, anything on behalf of your client? Any statement?
No, Your Honor.
All right. Well, I'm looking at helpfully, Ms. O'Brien, you put, I forget what document it was. It was your declaration that you filed where you kind of summed up the 6 points of what you were making here. So I have to find was there unlawful harassment committed? And I can't find that. This is a horribly failed relationship. It looks, there are statements made that are shocking by your father. But I don't find that they had the intent nor any more than what we call fighting words under the law. And the more recent events is what we're dealing with. Sounds like with the declaration from your mom and the divorce that occurred about 12 years ago, or at least you moved out of the purvey of your father's house about 12 years ago, is what I understand. And your mom's statement that supports you, that your father was not, was abusive, but I don't have any substantial corroboration of that. So I'm not making any findings there. I'm glad to hear that you're not afraid of your father, but these orders have to be based on the law. It's not whether your father is doing something wrong or doing something right, or how he talks to people right or wrong. That's not for the court to issue an order on. And I don't find on all of the information here that there's been unlawful harassment as defined by the law. So therefore the court cannot issue an order. However, it's obvious that folks don't want to have contact with each other. So you're going to have to make those decisions for yourself and of course for your children. But I don't have the basis of evidence here to issue this order. So that's the end of the hearing.
May I speak?
And this order of denial will be in the court file for all parties to access.
Okay, may I
So,
speak to Mr. O'Brien?
I'm not going to take court time to do that. So we'll do that on your own if you feel so inclined.
I don't. I just
But,
wanted to get a wham bam deal.
all right, we're going to move on. We're going to move on
thank
because I have
you.
2 other hearings. So
Your Honor, I would just
one can be
to contact me.
on their way. Pardon, Mr.
I would
Johnson?
I would invite her to contact me if she wants. I can. She has my cell phone number. So.
All right, that's one avenue.
Thank you, Your
Right.
Honor. Appreciate
Be
it.
on your
Your Honor, are we done right now?
You're done. You can be on your way.
Thank you, ma'am.
Here you go. How you doing? Keep going.
Oh, why not?
All right. Just want to be sure you're still with me because you can tell me now. Thanks. All right, Ms. Paris, why don't you come on up and have a seat? Ms. Carnes. Patience. And we're taking up case 2570. And Ms. Paris, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, Ms. Carnes, you'd raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, so give me a moment just to get the documents and petition and so forth up before me. So let's see, there was a temporary restraining order issued against Ms. Paris, protecting Ms. Carnes. And that's what we're going to talk about today, whether that continues after today. So Ms. Carnes, are you still asking the court for this order?
I read Molly's statement where she said that she has no interest in ever contacting me again, which is honestly really all I want. But I think I would feel more safe if we just had this just kind of like as an insurance, kind of like, because I am worried that like she may not stick to that.
Well, Ms. Harris, do you object to this order issuing?
Yeah, it's just
Okay.
a little silly.
Then let's have a hearing. And I'll start out with Ms. Carnes and know from both of you. Let me just, I've had a lot of hearings and I want to re-review what we had here so that I know where I'm coming from. And then I'll turn to Ms. Carnes first, and I'll hear from Ms. Paris. And all right. Open here, and I need to look at. All right, so Ms. Carnes, then you asked for this order, a temporary order was issued, so this was around March 17th that you came to the court. Tell me why this court should issue this order.
So I was looking through and I found that the first time I was contacted by Molly was back in July of 2023. And it's just been kind of a constant stalking of my profiles.
When you say that, what does that mean to you?
So it was like multiple times a day, I would get a notification that her username viewed my profile on TikTok. She would message me. I was also under the impression.
Let me step you back though. On TikTok, I mean, that's out in the public domain and you expect people to look at that. How is that stalking in your sense?
Because she would message me about my videos, accusing me that it was about her partner, which is my ex-fiance.
And so a message would occur after you saw that she accessed your TikTok, then you'd get the message, and the message would say that, that's what I'm trying to figure out. So
just kind of that he really just thinks that I really am interested in being with my ex Chandler, which I honestly I have no interest in speaking to them again, either of them. I just I hate that I had to make every single one of my profiles private just so that I could live my life without having to worry that like I'm being watched. Because that's like such an unsafe feeling. When I
all right, so then so the messages were that something about an ex.
Yeah, and then there was times when there was threats, which I submitted one of them.
Yeah, the one that you talked about back in November, is that what you're talking about? Being threatened to knock my teeth down my throat after I called her out for once again stalking my profile. So that goes back to November 2nd.
Yeah.
Okay, so that was, you had noticed she visited one of your TikTok or what? And then
I was hanging out with her partner when they were split up. Me and her partner had become friends again, and she was very worried because she loves them and she wants to be with them, and so like felt a little insecure. and took it out on me when the second that I was told like I wasn't wanted around, I left. I blocked on everything. I was like, okay, cool. This is my escape finally, because this has been multiple years now of a very toxic, abusive situation that I just don't want to be a part of it.
Jump you back. So November 2nd, you get that, and you didn't come ask for an order. 5 months later, you come for an order. So what did you think that statement meant at that point, threatening to knock your teeth out?
Well, to be honest, I understand where Molly's coming from, because I also used to be very protective over Chandler. And so like the thing that made me worried was Chandler and Chandler's family warning me about Molly and all, like telling me that she was a scary person. But I figured that, like, I had Chandler around at that time, and I thought, I would be okay. And I'm also just used to rolling over, especially in this dynamic relationship. It's just very messy. And I think I just figured I would let it, and we talked it through was the thing, and we both realized that we were being lied to about things, because I was told she was an abuser, like we talked it through. So that's why I didn't report anything.
Okay, and so after that November threat, and then you talked things through with Ms. Paris.
Yeah, and I thought we were okay.
All right, that's good. And then after that, the thing that got you to come to court was
so then all of a sudden, I got a call from my friend who was in town. I see her twice a year. She was at Buffalo Wild Wings. She wanted me to come, which is like just a few minutes down the road from me, right? So I drove there to go meet her, because I feel like as the victim of abuse, I can decide if I feel comfortable going to a restaurant that my abusive ex is a cook at. I wasn't planning on seeing her. I thought she would be in the back cooking. And I didn't speak to her at all. However, a few days later, I then received a message from Molly, which I submitted about going to that restaurant. And like, I just, then it was another message, and then another message. And it was just happened to be one of the like profiles that I forgot to block when I went through my block list, and it was all in my message requests. And then I didn't respond. And she then said in one of the messages, like, you should have fucking responded to the first message, because now I'm gonna tell the whole 9 yards or something like that. I'm sure you have the picture in front of you. But
so you added 3 images. You added 3 images to your petition, and it's nearly impossible for you to know when these happened and who writes what. So
okay.
Maybe
I'm sorry. I thought I had I know the first time I sent in stuff, things were corrupted, so things might not have fully been sent through the second time.
So they just say 123 and 128 and time and sluggy lady, and I can't determine who's
lady is Molly's account.
Okay.
And so that's a screenshot of my message request on Instagram, because I don't have her added on there, but I did forget to block. And so then all of a sudden, and I didn't even notice the messages at first, because like I said, they're in my requests, so I didn't see them right away. But when I realized that, like, because I haven't spoken to any of them since December, so I just figured, like, clean cut, never have to deal with it again. And then all of a sudden I'm receiving message after message, and she's viewing all my stories again, and I'm scared of getting like pulled back into that toxicity. And from messages from the ex and her current partner, and messages from her herself saying that she gets violent and abusive when she drinks, it scares me.
Did you ever see that when you knew her?
I did not, because I've only ever seen her like twice in person. I've never really interacted much with her in person. I mostly just know of her through stories from Chandler, which was like a year and a half of a story of like Molly abusing her. And so I don't know what's true and what's not. And so that's why I just figured, and I'm not the type of person, I just wanted to like let it blow over. But I had my therapist and my care coordinator and all of my friends that have been watching this go on for years just finally just be like, you have to do something. So I am.
Right. Okay. All right. And anything that you wanted to comment on what was filed by Ms. Paris?
Just the idea that it's a retaliation. It's really not. If it was, I would have, gone with the years of abuse evidence that I have on my phone against her partner if it was retaliation. And I'm not doing that because I just want this to be over. But I also really respect the fact that Molly's willing to not reach out to me again. And because that's at the end of the day what I want, because in a way, it's like, I know that me going to the restaurant her partner works at upset her clearly. But for me, I feel like it's better to face the devil you know than the one you don't. So like, I know how Chandler hits. I don't know how Molly does, but I've heard stories and that just scares me. And I just think that like, I want out fully, and I just want to move forward with my life, and I can't do that if every move I'm making on social media is being stalked. It makes me paranoid. And I don't want to live that way anymore. There's a reason that I have walked away. There's a reason I moved homes. Like, I want to leave for real, which includes having my ex's girlfriend leave me alone. But I appreciate the response, and I understand why Molly might think some of the things that she does, but I just want out, and I don't want to get hurt in the process.
All right. So, all right. So, Ms. Paris, then you did file a 4-page response, and I appreciate that. It's always helpful to have things put to writing. And I've had an opportunity to look at that before court, and again, re-reviewing things on the right page here. Anything else, Ms. Paris?
Yes, I would like to say there has been contact between Miranda and Chandler's mother, Chandler herself, and she has reached out to both of Chandler's siblings who are younger than us and definitely younger than her. And she has been let know. Chandler had explained to her after everything that has happened.
I don't want to hear anyone talking to me about what Chandler is saying.
It is because
not of issue.
Miranda has been let know that I was misrepresented. So I do think it's interesting that she's continuing to bring up the fact that she's heard stories. Chandler has a year and a half of this, but it's within the last few months, like at the beginning of everything, Chandler reached out and was like, hey, by the way, I did make up like all of that. So I'm not going to keep disrespecting Molly and choosing to hang out with you because it wasn't fair that I treated her like that, basically. And also mainly just this whole concept of that I have been continually messaging her and stalking her. I cannot comment on anything from the July stuff because I honestly don't remember at all. But what I do have is the messages on TikTok, because the whole reason I had reached out onto her TikTok account, besides looking, because it's social media, she saw that I viewed her account, and then she had made a post on her story saying like, I see you, bitch, you mad? And so I replied, and I was like, oh, no, I'm not. Blah, blah, blah. And that's the where you see the ones from me threatening her the first time on November 2nd. And I don't understand where she's gathering this idea that she's in danger if she's continually reaching out to me, which is shown in the first exhibit where she came to
exhibits,
or
your exhibits.
My exhibits.
Yeah.
So exhibit A, I guess. And this is also why I wanted to argue at least the drug assessment.
These are from December 11, right?
Yep.
Okay.
And the threat happened on November 2nd. We became friends basically that day after finding out that we were both getting lied to. And she wanted all three of us to be friends. She came to pick up drugs from my place of residence, which is why I think it's funny that she's filing for a drug assessment and talking about my
this court
drinking.
isn't going to be ordering anything like that. No matter what I do, we don't have that authority. So, but this is evidence then that you've been having this.
We've been having a situation where she wants to hang out, and the last contact that I have of her is from December 23rd. That's this exhibit B, where she is asking to come hang out with me and Chandler to go to a karaoke bar, I think it was.
And then, all right, what's your exhibit C? I can't quite figure out.
This was proof of
talking to
her
who?
coming to Chandler's workplace. And the reason that was like, yeah, cool, you can go where people work, I guess. She has been well aware of Chandler's scheduled days and what Buffalo Wild Wings, where it is, you know, she's gonna be there. And she's not just a cook, she's a server now, and would be in like knowledge of that because they were hanging out when that started. Okay. And this basically is just a retaliatory thing because the only reason this was filed when she was referring to her exhibit of the like me saying she should have responded, it was because I have been continuing to find out information that she has been talking about to like multiple people. I found out that her mother has found out about like my addictions past and like homelessness and things like that. And she has continued to make posts about me, but it isn't indirect, so technically it could not be, but talking about how at least I know my ex is crazy on the day that Chandler let her know she didn't want to hang out anymore. And it kind of just seems like she's mad she didn't get the last laugh type of thing whenever Chandler stops talking to her, because that's when, around that time is when she petitioned this and then went and through and deleted all of the posts she had made, which kind of like shows she knows that posts aren't going to line up with actions type of thing. Yeah, it's just a little silly.
All right, so your point here is that that there isn't a basis to find, tell me if I'm wrong, there's not a basis to find that you're intending to commit unlawful harassment.
Exactly. Because I have never been asked to stop contacting her. I went through every message that I have on my phone given. I cannot talk about July. I don't have any of that. There has never been a Molly, you need to stop contacting me. I've gotten her being antagonizing on the story and then wanting to be my best friend for a while. And then once she had stopped talking to Chandler because Chandler cut it off, that was the day she also cut me off. So it's kind of like she was, yeah, this is just silly, basically. There's no harassment. I look at Instagram or TikTok, I apologize. It's been public up until literally 3 days ago. So it seems like she's she has not been putting forth the effort to make it known that I'm scaring her or making her feel paranoid or harassed. So this was just a bit silly, in my opinion.
Yeah. So, Ms. Carnes, I'm not issuing an order against this. I don't find it silly. You know, that's up to Ms. Paris to decide how she feels about it. But there just isn't, and I have to find, is there an intent on Ms. Paris to commit unlawful harassment against you, all of her actions specifically to cause you emotional distress and actually causing it and having no lawful or legitimate purpose for it, I can't find what the law defines as unlawful harassment. So there will be the order ends. There will be no further order going forward. I think the two of you have made it clear to each other you're not real interested in having any contact. So I suggest that you go along those lines. And so that's it for today. I'll write an order that ends the matter. And that's in the court file. So
Well, thank you so much.
The two of you.
Have a great day.
Thank you, Your Honor.
So long.
Well, thank you so much. Have a great day. I mean, come on now. Come on now. Ladies and gentlemen, that's all we have. That's it. That's all she wrote. This is the end song. And I am your Lone Wolf Usul. I'm a tired Lone Wolf Usul. I've been putting together all these cool little stories for you. But right now, as this show ends, another show begins. So stay tuned, ladies and gentlemen. We are redirecting right over into Colin. Definitely not Cromwell. And he has a very interesting story about the fall of the House of Buckner. And ladies and gentlemen, all that gets started right now. We'll see you there. Have a great one. Come by on the weekdays, by the way, just like Mom said. You know, weekdays, 8 p.m. Central Time, 9 p.m. Eastern Standard Time. I do this type of thing every single day. Lots of videos coming out. Stay tuned. Like, subscribe, check the little bell icon. You'll get a notification. And I'll see y'all at college. Y'all have a great afternoon.